What's up, everybody? What's up, MGTOW? Hope everybody's doing well. So this video is going to be diving a little bit more into the Uniform Law Commission. I was able to find some more information about it. For one, the head chairwoman of the Family Law Division's name is Barbara Ann Atwood. She's a law professor at Arizona University. She's also written several papers on marriage and modern relationships in relation to law. After looking through some of the documents of the ULC and its members list, it seems that one of the main focal points of the ULC Family Law Arbitration Committee is just that, arbitration. What arbitration seems like in this context is a way to avoid having marriage contracts being brought into an actual civil court. Atwood uses some interesting logic to promote the use of arbitration. Just a few quotes from Atwood's paper titled Marital Contracts and the Meaning of Marriage. This first quote demonstrates that MGTOW are not the only group talking about the unreliability and abstraction of modern marriage agreements. Quote, "Marriage as an evolving institution." Historian Stephanie Kuntz reminds us that for much of history, marriage was an arranged union designed specifically to bring together families or kin groups for inheritance, property control, and other economic or political reasons. Love-based marriage, Kuntz emphasizes, is of relatively recent vintage and has inevitably destabilized marriage as an institution. As she observes, quote, "The very features that promise to make marriage such a unique and treasured personal relationship open the way for it to become an optional and fragile one." End quote. Likewise, sociologist Andrew Derlin suggests that the changing goals of marriage have contributed to its fragility, with today's couples viewing marriage as a vehicle for personal fulfillment and self-realization rather than a commitment for lifelong sharing. She continues down further. Changes in the legal regulation of marriage inevitably affect, quote, "the way we think about marriage." As the law becomes more receptive to private ordering of marriage, for example, those legal changes may not only reflect but also promote a view of marriage as less a commitment for life and more a kind of serial monogamy. Marriage law that explicitly contemplates varied, changing, contextualized forms of marriage may in fact be more compatible with contingent, problematic, but nevertheless enduring human love than the refined abstraction we now call marriage. End quote. Well, isn't that something? I had to read that last sentence a few times, but yes, it does seem that the chairperson of the most powerful family law commission in the United States just referred to modern marriage as an abstraction. The arbitration is argued to be needed due to the infinite numerances of case specificity. Since marriage is no longer a fixed social contract but rather an abstract concept, it becomes very difficult to enforce and equally difficult to make any objective value judgments on either partner's role in the contract. It seems that part of the arbitration's use is to keep marriage law contract adjudication out of actual courts for discussion, while at the same time using the courts to enforce any settlement agreements. In fact, according to Atwood's paper, over, quote, 90% of divorces are settled out of court, even though, quote, valid concerns exist about distortions of bargaining power at the end of marriage. The fact that arbitration is a grueling process involving the revelation of property and privacy seems to be one of the factors leading to settlements, as people don't want lengthy investigations into the daily details of their marriage. The revised Uniform Arbitration Act deals with this subject in detail, and I might return to it in a future video as it is a seemingly complex topic. Just a quick quote from the project proposal and guidelines form. Quote, "But the issues present in the family law cases vary from the more commercial focus of the UAA and the RUAA. As an example, traditional arbitration does not address the need for arbitrators' decisions to be modified under future or possibly unforeseen conditions." Yeah, you mean like when that guy in England got wealthy after his divorce and his wife sued him for more alimony? Moreover, in commercial arbitration does not allow for rulings on substantive law. But in family law cases, an arbiter must make written findings of fact to support the award of spousal or child support. The finding of fact is critical to the appeal and modifications. The finality of commercial disputes is not replicated in a more dynamic and evolving family relationship." End quote. This statement here sheds some light onto why couples cannot simply draw up a contract beforehand specifying the roles, duties, responsibilities, and penalties of marriage in the same way commercial legal contracts allow. The second interesting point is that of the second highest member of the ULC Family Law Committee, Lorie Fowlke. Fowlke is a practicing legal professional and a senior partner at Scribner Fowlke Law, which according to their website specializes in family law. Although it's pretty obvious that she specializes in family law as her paid profession, I will give her credit for writing a book called Thinking Divorce, Think Again, which is at least described as warning couples to examine their reasons for divorce. Fowlke also served as a Republican representative in the House of Representatives in Utah from 2005 to 2011. So from these 2 points, we can kind of see a few things. One, that there is an obvious conflict of interest with some of the board members of the ULC also working in the family court system and being paid for laws that they are suggesting to be changed. And also, we see that there's definitely a slippery slope once you start defining marriage as anything more than something between a man and a woman for the purposes of raising children. So that's all I got to really say about this today. Have a good day and go MGTOW.